Subscribe to our channel and press the bell icon to never miss any update from Rouse IAS Study Circle. Join the only official Telegram channel of Rouse IAS Study Circle to get the relevant materials and important updates. Hello and welcome to the Daily News Simplified. The what, why, and how of the newspaper analysis from a civil service examinations perspective. So today we are going to discuss the Hindu Delhi edition dated 6th May 2022. The topics to be discussed have been displayed on your screen and the timestamping of the same has been provided in the description box below. So today we will start with our session closely analyzing the data point. This has appeared on page number 7 in today's The Hindu Delhi edition and it relates to the custodial deaths which has recently taken place in the state of Tamil Nadu. However, the phenomena is not restricted to the state of Tamil Nadu alone, it is a pan-India phenomena, though the numbers, the intensity varies state by state. So that is why in today's session we will discuss in detail the broader topic from the mains perspective, that is the prison reforms. As far as the UPSC's scheme of syllabus is concerned, this topic falls under the mains General Studies paper 2 in the section of Governance and Constitution. The question can also be asked from the social justice perspective because the under trials, the prisoners which are there lodged in the prisons are also one of the most vulnerable sections which we do not talk about. So in line with this, let us start with our detailed discussion. We will come to this particular pictorial representation later on, but first let us understand the background of the criminal justice system. Now, first of all, you think that what do you understand by the criminal justice system? Which is the most important word among these three words? It is the justice. Now, justice has an ethical meaning. Justice is not related only to the victim, but also to the accused. The prisoners, the accused also have their certain rights which are to be respected. And that is also guaranteed by our constitution because Article 21 provides the freedom to live with dignity to each and every citizen of our country. So the criminal justice system is basically based on the principle of justice which must be ensured to everyone. Second, the rule of law is the supreme force, the supreme power according to which the criminal justice system of any country must work. And the third important thing is that if you holistically understand this particular system, every organ of the state, that is legislature, executive, as well as judiciary, is associated with this system. The reason being, legislature make the laws which deal with crimes. The executive enforce those laws, and the judiciary deals with the overall delivery of justice. It provides compensation, it rules for punitive actions which are to be taken. That is, judiciary is basically tasked with to oversee the justice mechanism. And in this very regard, two important organizations, that is the courts as well as prisons, are very important. Now here we are dealing with the prison reforms, and that is why we must understand that why prisons are built. Now there are two basic purposes of prisons. First is to enforce the punitive actions against those who have found guilty. But these punitive actions are not revenge. There should be a difference between punishment and revenge. Revenge is a negative connotation, but punishment is not a negative connotation. Punishment is given to certain person in order to reform or rehabilitate him. And that is why prisons are basically tasked with the reformative as well as rehabilitative approach. All the accused, all the persons who are found guilty and are sent to the prison, the primary task of the prisons is to reform them and reintegrate them with the society. But then the question arises that how many of us feel that Indian prisons are successful in reforming and rehabilitation purposes? Are we able to reintegrate the people who are sent to prisons with our society? Unfortunately, the answer is not satisfactory. And leave aside the protection of rights of the criminals or the prisoners, we are facing a huge number of custodial deaths in our country. And this is the very context of today's article. Recently, a man died in the police custody in the state of Tamil Nadu, that is Chennai. And few years back, there were a lot of cases which were reported from the same state, that is Tamil Nadu, for the custodial deaths. And as we have discussed, that this is not restricted to the state of Tamil Nadu alone. For example, Uttar Pradesh has recorded the highest number of deaths in the judicial custody in the last 6 years among all the states. And despite the fact that this phenomena is present pan India, the data on the prosecution of these issues are far more disturbing. This particular graph shows the custodial deaths in the period and the cases recommended for compensation, disciplinary action, and the prosecution by National Human Rights Commission. Between the period of 2016 to 2022, the total number of custodial deaths reported was 11,419. And out of 11,419 custodial death cases, only 1,184 were provided monetary compensation. Only 21 cases faced the disciplinary action, and there was a zero case of custodial death where prosecution was recommended by NHRC. Now imagine, not even a single case has invited prosecution by NHRC out of this 11,419 cases of custodial deaths. In this very regard, here let us understand that what is the basic difference between police custody as well as judicial custody. Now, many a times these words are interchangeably used. However, there is a significant legal difference between these two terms. Now, police custody refers to the person who is in the custody of the police, that is, within the police station. When a police arrests a suspect in order to prevent him from committing other offensive acts and they are lodged in the police station, it is known as police custody. However, when that accused is presented to the court of magistrate and is then sent to the prison, is known as judicial custody. Now, as per the law, there are different time frames for the police custody as well as judicial custody. Police custody may extend only up to 15 days, but the judicial custody may extend up to 90 days. In the police custody, the accused are often questioned, they are interrogated, and that is why it takes within the premises of police station. But as we have discussed that the custodial deaths is one of the major issues which our accused prisoners face in the police as well as judicial custodies, let us discuss this issue in detail. First of all, we need to understand the status of our Indian prisons. As we have already discussed, that Indian prisons faced a huge number of custodial deaths every year. Now, this particular picture shows you the custodial deaths in police as well as judicial custody. Out of total number of deaths, that is around 1697, that is around 1700, 403 cases took place alone in the state of Uttar Pradesh. This data is during the period April 1, 2019 to March 31, 2020, and the source, as you can see, is Home Ministry. That is why UP is the leading state. The second major point in the status of our Indian prisons is that the prison occupancy ratio is far higher, that is 115%. It means that if there is a prison which can accommodate 100 prisoners, 115 prisoners are jam-packed in those prisons. And this leads to overcrowding of our Indian prisons. And out of all these prisoners, the disturbing fact is that 68% constitute just the under trials. Now the question is that who are under trials? Under trials are those people who are yet to be found guilty by the courts, but because of their poor socio-economic conditions, they cannot afford lawyers or they cannot afford their bail and they are still present in the prisons. So those are under trials, and majority of the population in the prison, that is 68%, are those people who are not yet found guilty. And in this very regard, the last major point is that we do not have adequate number of prisons in our country. Most of the prisons which today are present in our country were built during the British period. And we all know that since that period, our population has tremendously grown. And so the number of prisoners have also grown. But we have not constructed new jails to accommodate those prisons. And that is why Indian prisons today are in one of the most poor conditions. Now we will closely look at what are the various issues which are faced in our prisons. First and foremost is the poor basic services. For example, the sanitation services, the food services, the newspaper services. All these services are not provided in our prisons in the way they should be. And because of this, there is a lack of reformative approach in our prisons. According to our law, there should be a welfare officer in our prisons. But various reports suggest that most of the prisons do not have welfare officers. The next major issue is of discrimination. The prisons are being discriminated on the basis of their caste, sex, religion, as well as economic status. On regular basis, you come across several news whereby several influential people who are there in prisons are given disproportionate services. On the other hand, the people from the minority background, the people from the poor socioeconomic background, they are treated just as animals. So there is a widespread discrimination in our prisons, and this in turn leads to the violation of the fundamental rights. In this very regard, now let us examine that what are the various steps which are already being taken by Indian government. The first is that in 2016, the government came up with the new prison manual. According to this manual, there should be a jail visiting advocates who can visit the jails, talk to the prisoners, and protect their legal rights. Second, there should be legal literacy classes in the prison themselves in order to empower the prisoners and make them learn about their legal rights. In this very regard, the third important thing is that there should be legal aid clinics. The second important step taken by the government is the e-prison project. This is done in order to digitize the prison records in order to streamline various formalities like bail procedures, etc. The third important point is that government has also advised to establish open jail systems. In the state of Maharashtra, there are several pilot projects being run to establish open jail system in order to break that particular mentality that prisoners should be treated as animals and they should be locked within the narrow chambers of the four walls. And the fourth important thing is that government also came up with the draft national policy on prison reforms. But as we know that the policies are better made on table, but their implementation is a bigger challenge. In this very regard, we should also know what should be the way ahead in this particular scenario. The first is that government must implement the recommendations provided by the Mullah Committee. According to this committee, there should be a single body named National Prison Commission which will be the overall coordinating body in order to reform all the prisons. Second, there should be a clear cut separation between the under trials as well as hardened criminals. Now, we have discussed that what are under trials, those people who are not yet found guilty, and many a times these under trials are charged with minor offences. On the other hand, we have hardened criminals, those people who are charged with serious offences like rape, murder, extortions, etc. So, if the people who are charged with the minor offences come in contact with these hardened criminals, there are very high chances that these under trials might not be reformed and they are highly influenced by these hardened criminals and gradually they themselves will become the part of these criminals. So that is why there should be a clear cut separation between under trials and hardened criminals. And the third important recommendation was that there are several under trials prisoners who face mental issues. There are very high suicidal rates in our Indian prisons, and that is why those prisoners who are mentally challenged shifted to the mental asylums. Next, more prisons should be built in order to accommodate the rising number of prisons, and all those prisons must be digitized. Third important thing is related to the human resource development of the prison staff. There should be capacity building drives of the prison staff in order to sensitize them towards the rights of the prisons and in order to provide them with the creative approaches to reform those prisoners. And the last important thing is the unified prison management system. Now, this unified prison management is already working in Tihar jail in Delhi, and it has provided us with the desired results. So, this practice should be spread across India in all the prisons. So, now we come to the end of this session where we have discussed about the issues related to Indian prisons. And now, in brief, we will revise this topic once again. Now, this topic has appeared in the section Data Point at page number 7 in today's newspaper. The context of this particular topic is that recently a man has died in the police custody in Chennai. In this very regard, we looked at certain data related to the prosecution as well as disciplinary action which was recommended by NHRC. And here we learned that out of 11,419 cases, not even a single case has received a prosecution by NHRC. After this, we discussed what is the basic difference between the police custody as well as the judicial custody. We also discussed the basic philosophy of the criminal justice systems and the basic idea of the institution of prisons, which was to reform and rehabilitate the prisoners. Then we discussed about the status of the Indian prisons, the issues related to the custodial deaths, high prison occupancy ratio, under trials, as well as the inadequate numbers. Then we came across the social issues which are faced in our prisons related to the poor sanitation, discrimination, violation of rights, as well as lack of reformative approach. Then we discussed that what were the steps which are already being taken by the government in relation to the new prison manual 2016, e-prison project, open jail systems, as well as draft national policy on prison reforms. And in this line, in the last, we discussed about the way ahead, recommendations of the Mullah Committee, the idea to establish more digitized prisons, capacity building of the prison staff, as well as following the unified prison management system across all the jails. Our next topic is in relation to the Naga peace talks. This topic has appeared in today's The Hindu Delhi edition at text and the context page. So the latest context of this very news article is that recently the annual report by Ministry of Home Affairs was released, and it has said that NSCNIM, that stands for Nationalist Socialist Council of Nagaland, was involved in 44% of the total insurgency related incidents in Nagaland in 2020. That means that NSCNIM has emerged as one of the most powerful insurgent groups in northeastern India. Now, this insurgency becomes very important in the backdrop that in 2015, the Union government had signed a framework agreement with the NSCNIM to find a solution to the Naga political issue, and the organization promised to surrender the arms and boycott any armed rebellion. But the issue is that the negotiations of that talk are yet to be concluded. Now, the insurgency related questions in UPSC mains are very regular, and almost every year there is one question at least on northeastern insurgency. For example, in GS3 UPSC 2017, the question was asked as follows. The northeastern region of India has been infested with insurgency for a very long time. You were asked to analyze the major reasons for the survival of the armed insurgency in this region. The very next year, UPSC 2018 asked, the left-wing extremism is showing a downward trend but still affects many parts of the country. You were asked to briefly explain the Government of India's approach to counter the challenges posed by left-wing extremism. So regarding the today's news article, in today's session we will discuss the historical context of this insurgency related to the Nationalist Socialist Council of Nagaland, and we will also look the various issues which are involved in this. So the history of this movement goes back to the British period when India was a colony of British. The British entered into the northeastern India for the demand of timber. But there they realized that there were several tribal groups having a common background but very different cultural practices. And that is why they decided to keep those cultural practices but within the overall ambit of British power. But we all know that British looted that region up to a very huge extent, and the socio-economic conditions of the tribal groups further deteriorated in that particular area. Now jump to the period of India's independence, that is the decade of 1940s. When it was almost clear that India is going to be independent, various tribal factions were confused regarding their own future status. They were wary about the feeling that the plains people, that is, the people living in the plains, who were then called as outsiders, will enter their areas and they themselves will be ousted from their own region. These outsiders will invade those areas, they will develop their economic centers in those areas, and the culture, the original, the root culture of tribal groupings in those areas will be devastated. And as a reaction, in 1945, Naga National Council, that is NNC, was established. And this NNC, under the leadership of Mr. Fizo, declared their own independence on 14th August 1947, that is one day prior to India's independence on 15th August. And on this very day, they demanded the independent state of Nagaland, which will not be the part of the Indian Union. They demanded a separate sovereign state. In line with this, in 1950, in order to further pressurize the Indian government, this NNC was further divided into two major groupings. The first was the Naga federal government, and the second was the Naga Federal Army. Now, NFA, that is the Naga Federal Army, was an armed group which aimed to pressurize the India's government in order to fulfill their political demands. And in the backdrop of this armed insurgency, the Indian government sent its armed forces to the northeastern India, and AFSPA was imposed in those areas. Still, AFSPA is continuing in several areas of Nagaland. Further, jumping to the 1975 Shillong Accord. The Indian government signed Shillong Accord with these Naga tribal groups, and they promised to surrender their arms. But there were some leaders of this very organization who were not happy, and they decided to divide the NNC, and then the Nationalist Socialist Council of Nagaland was formed. Further division of NSCN led to the creation of NSCN-IM. The major demand of the NSCN-IM today is creation of Greater Nagalim. Now let us understand that what is this Greater Nagalim. Now if you go by the northeastern India, this is the rough map of northeast India. Now Nagaland is somewhat here. However, several Naga tribes find their presence in the state of Assam, Arunachal, as well as Manipur also. So the concept of Greater Nagalim is that all those areas where the Naga tribes exist must be combined together in order to make a new Nagaland state. So that means that NSCN IM demands certain areas of Arunachal, Assam, as well as Manipur. So this is the historical background of the movement of Nationalist Socialist Council of Nagaland. But their demand have several issues which has led to the stalemate of peace accords and peace negotiations. The first and foremost is the challenge to India's unity and integrity. If there is some organization who is demanding for a separate sovereign state from India, it directly challenges the India's own sovereignty. The second major issue involved is of state reorganization. Even if we accept the demand of Greater Nagalim, it will be very difficult because then the state reorganization must have to be done. And negotiations with Arunachal Pradesh, Assam, as well as Manipur might not be concluded because these states have clearly stated their claim that they will not give an inch of their area to any organization. The third major issue is the internal disputes within these insurgent groups. For example, the Naga nationalist political groups. Now, this NNPG comprises of 7 organizations. They are also the extremist organization who on some issues are in direct conflict with the NSCN-IM. For example, the groups in NNPG are ready to hold peaceful talks with the Indian government and become part of India. And further, there is one larger issue at stake also. If Indian government adhere to the demand of these organizations, there will be a ripple effect across India. The insurgency in Jammu Kashmir, The Maoist movements in central and central east India will increase their activities also, because it will signal that Indian government has ceded to the armed rebellion of some particular group. So that is why this issue needs to be tackled not on ground but on political tables, and the negotiations must be held peacefully in order to come at certain mutually beneficial conclusions. So now we will move with our next topic. This topic is in relation to the Collegium system, which is tasked with the main function of the appointment of High Court or Supreme Court judges. This topic has appeared on page number 11, and the topic reads: Collegium recommends two names for the Supreme Court. As far as the syllabus is concerned, this topic falls under the General Studies Paper 2 section in the subsection of Constitution and the microsection of Structure, Organization and Functioning of the Judiciary. Going by the previous paper analysis, in 2017 the question asked was: critically examine the Supreme Court's judgment on National Judicial Appointments Commission Act 2014 with reference to the appointment of judges of the higher judiciary in India. Now the backdrop of this particular question is related to the appointment as well as independency of judiciary. In this very regard, in today's session let us discuss the Supreme Court or High Court judge appointment. First, we will look at certain constitutional provisions. Our constitution says that Supreme Court or the High Court judge must be appointed by the President of India by warrant under his hand and seal, respectively under Article 124 Clause 2 and 217 Clause 1. That means that the appointment is to be done by the executive body, that is the President. The Constitution also prescribes the age limit for the High Court as well as Supreme Court judges. It says that judges of the Supreme Court shall hold office only by the age of 65 years, and the corresponding age for the High Court judges is 62 years. But an important thing is that Constitution does not provide for the method or manner of the selection of the High Court or Supreme Court judges. And here lies a blank or loophole, because the Constitution does not explicitly provide for the mechanism of their selection. In this very regard, three judge cases are very important, which ultimately led to the developing of what we today call as Collegium system. So at the time of emergency and with the help of 42nd Constitutional Amendment Act, the executive became a real center of power concentration, and all the powers were vested in the hands of executive. In that very line, these judge cases are important. Now, if you closely analyze this particular provision of the Constitution, it says that the President, which is an executive body, will appoint the High Court judge. And we all know that President has to act on the advice of Council of Ministers. In this very sense, the Council of Ministers, that is the executive body, could have become the main appointing body of the Supreme Court or High Court judges. And this would have led to direct conflict between executive and judiciary. Now, because we all know that independent judiciary is the basic thing which is required for a proper federal government. And in this very regard, every effort should be made in order to preserve the independence of judiciary. However, in the first judge case, Supreme Court ruled in the favor of executive by narrowly interpreting this particular provision. Supreme Court said that the opinion of the Chief Justice is merely consultative in nature, and the power of the appointment exclusively lies with the central government. But the judgment gradually changed in the second judge case, whereby Supreme Court said that the government does not enjoy the primacy, and the role of Chief Justice of India or the Chief Justice of High Court, that is in regard to the High Court appointments, is also important. But here also there was a threat that power could have concentrated in the hands of Chief Justice of Supreme Court or High Court. So the Supreme Court in third judge case said that Chief Justice of India or the Chief Justice of High Court will not be the sole appointing authority. The CJI shall consult 4 senior-most judges of Supreme Court, and the opinion of the members, that is these senior-most judges of Supreme Court, shall be in writing. Now this body, that is CJI and 4 senior-most judges of Supreme Court, which were to be consulted by the Chief Justice of India, came to be known as the Collegium. Further, the Supreme Court also ruled that if the majority of the Collegium is against some person, that particular person shall not be appointed. Even if two of the judges have reservations regarding the appointment of some particular person, CJI would not press for such appointment. Further, it also said that the High Court judge of outstanding merit can be appointed as Supreme Court judge regardless of his standing in the seniority list. So I hope till now it is clear that what exactly is the collegium system. This collegium system is not mentioned in the constitution. It came via the Supreme Court judgment in the third judge case. But there are certain issues involved with the working and functioning of this collegium system. The first issue is related to the lack of transparency. It was observed with the establishment of the collegium system in initial days, the system worked in complete secrecy. Further, the appointment of the judges in High Court and Supreme Court were also accused with the charges of nepotism. It was witnessed that there were huge number of cases, accusations of favoritism and preferential treatment to the members of judicial fraternity. Further, because there were no clear-cut guidelines to appoint the Supreme Court or High Court judges, there was increased politicization of the judiciary. Several political appointments were made especially to the High Court. And the last major issue is related to the absence of permanent commission. The Law Commission in 121st report as well as National Committee to Review the Working of Constitution in 2002 has pressed for the need of the National Judicial Service Commission for the appointment of judges. They are of the firm opinion that there should be a dedicated body so that the powers are not concentrated in few hands and there is a complete transparency in working and functioning while appointing the judges to the higher judiciary. So that was all in relation to the Supreme Court or High Court judges appointment. In today's session, we looked at constitutional provisions which says that President appoint the judges of Supreme Court and High Court and the age limit for the Supreme Court judge is 65 years and High Court judge is 62 years. But we also learned that the Constitution does not provide explicitly the mechanism to appoint the judges of higher judiciary. This mechanism was laid down by the help of judge cases and the collegium system came as the outcome from the third judge case. In this very relation, in the last we addressed certain issues which are related to the lack of transparency, nepotism, politicization of judiciary as well as absence of permanent commission despite the recommendation by the National Committee to review the working of Constitution. Our next topic is from page number 5 and the topic reads Center questions the environmental impact of Jog Falls project. Now this topic is mainly relevant from the prelims perspective because every year there are 2 to 3 questions which are location based. So you need to know that where these Jog Falls are located, in which state they are present, on which river they exist. So all these factual details which we are going to discuss today might be very helpful in solving your prelims question. So this is the picture of Jog Falls and as you can see that these are purely vertical falls. Now there is one technical name that is the plunge falls. Now plunge falls are those waterfalls which are purely vertical in nature and when the water comes down they leave their bedrock. There is a gap between the water as well as this rock because the water flows from the surface directly in this fashion and there exists certain gap between the bedrock as well as the waterfall. These type of waterfalls are known as plunge falls. So these Jog Falls are located in the Shimoga district in the state of Karnataka and there are various alternative names of these Jog Falls too. For example, they are also known as Gerusope Falls, Gersopa Falls and Jogada Gundi Falls. It is one of the highest waterfalls in India. This point is very important. It is one of the highest waterfalls. It exits on the Sharavati river. Now Sharavati is the west flowing river and its mouth lies in the Arabian Sea. Here again there is one more technical terminology that is cataract. Now cataracts are very large waterfalls. In relation to this, there is one more important name which is of a dam that is Linganamakki Dam. The river water which flows to this Jog Falls is controlled by Liganamakki Dam, which has been constructed upstream from the Jog Falls for hydroelectric power generation. So these were the factual points related to the Jog Falls which can be useful in preliminary examinations. So now is the time for the question of the day. The question from the yesterday's DNS is relation to the GST compensation mechanism. The question asked, with reference to the GST compensation mechanism, consider the following statements. First, the GST compensation fund is maintained outside the Consolidated Fund of India. Correct. Second statement, the GST compensation is to be paid at the end of every financial year. Incorrect, because the time is 2 months, not every year. Statement 3 is the entire surplus in the GST compensation fund is distributed only among the state governments at the end of every financial year. Incorrect. So A option, that is 1 only, is the correct answer. The question from today's DNS is as follows. The waterfall is located on the Sharavati river and is one of the highest waterfalls in India. They are a perfect example of plunge pools. You have to identify that these lines are talking about which waterfalls among the given 4 options. A. Dhuandhar Falls, B. Dudhsagar Falls, C. Kunchikal Falls, or D. Gersopa Falls. So that's all for today. All the very best. Study hard.